there's a precedent previously of mum taking children out of school. They now have no GCSEs, no qualifications.
Oh dear.
Dad has some concerns about that. Is that again a case of going back to court? Or
Absolutely it is. We have to have both parents or those people with parental responsibility in agreement.
My daughter's father, she initially had some reservations about her security and how safe she felt with him. He ended up assaulting my partner. There wasn't sort of enough evidence to charge him.
I can hear in your voice that you're really worried about this. Don't be put off by the fact that the police have said there isn't enough to charge him. The family court have a much lower bar than the criminal court.
She took him for a holiday without my consent.
Has she brought him back?
Not yet, and I'm not sure if she willing be coming back.
This isn't going to be a straightforward application. The Hague Convention's going to have to be considered. That would be where I'd be most concerned. Hi everyone and welcome back to the Legal Queen live show. I am your host Tracy Maloney, aka the Legal Queen. I am a practicing family law solicitor and have been now for over 20 years. During that time I've helped thousands of people with their divorce questions, with their finance questions, and also with questions around their child custody matters, shared care, things like that. So if you have a question that you'd like to ask me, then by all means join me on Discord, pop up your hand and I'll get to you as soon as I can.
a friend who's been through the court system has got a child arrangements order in place, which specifies contact for the father through a contact centre, but doesn't specify how long that should be. And it's been 5 years now of contact through a contact centre.
Oh, wow.
He would like to change it, but
Yeah,
it's
absolutely.
getting expensive. But doesn't necessarily have the funds to go
Yeah.
back through the courts. Is there any other way of doing that apart from going back to court?
Well, look, I mean, the first thing I would say is that it's really unusual to have contact centre contact go on for that long. Normally, we will have contact centre contact until we are satisfied that the children are no longer at risk. And then usually the court's preference will be to move that to supervised contact, where a family member or a friend is supervising. So really unusual for there to be a final order where it ends there. All he can do is to go back and make an application to vary. Now, I know that you've said in your question he doesn't want to go back, but unfortunately, it's a court order. So the only way that we can ignore that is to have another court order that will take precedence over that one, or even if that one is thrown away. I mean, the thing that I suppose I've overlooked is given that it's been 5 years, is he able to speak to the other parent? Have they kind of reached a point where maybe mediation is possible? Because that's the other thing. If both parents are in agreement to putting the order to one side, that's okay. You know, that they wouldn't be seen to be breaching the order if they're both in agreement that actually it can progress to supervised contact or even just normal contact. So maybe mediation would work here, because 5 years is a long time.
Yes, and it has an impact on the children, doesn't it? I don't think
Absolutely.
it's not that he doesn't want to go back to court. I think it's the cost of going back to court. So
But-
that's really helpful. Thank you. Then
But he can.
my second
But
question.
if I can
Sorry.
just jump in, he can do it himself. I always like to add that, because I don't want people to assume that they have to get a solicitor in order to take matters back to court. You can do it yourself. Absolutely.
Brilliant. Thank you.
Okay.
And not tied into that, but the second question is
Yeah.
same family actually, but so mum has taken the child out of school, has fallen out with the school and taken the child out of school, claiming she's going to homeschool.
Yes.
Dad has some concerns about that. There's
Yes.
a precedent previously of mum taking children out of school. They now have no GCSEs, no qualifications.
Oh dear.
He would like the child to stay in school. He still has parental responsibility.
Yes.
But because he's not the main carer, he doesn't have the lives with order. The school are sort of keep communication to a limited with him, and he's not sure how to how to challenge that really.
Yeah.
Is that again a case of going back to court, or how would you go about sorting that out?
Absolutely it is. When it comes to our three big ticket items, which is education, religion, and medical issues, we have to have both parents or those people with parental responsibility in agreement. Okay, when it comes to the day-to-day care of a child, what they wear, what time they go to bed, what they eat, not necessarily. Usually then those decisions are left to the parent whose child the care is in. But the big ticket items, absolutely. So if mum is threatening or has already removed the children from school and dad doesn't agree, Absolutely. Make an application, C100 form. It's a specific issues order that he's going to tick. And, you know, he may want to use that and at the same time ask for the variation to his existing order to get it out of the contact centre.
That was my thoughts, yeah.
Yeah, and then he can obviously say to the court, look, I really don't think it's in the child's best interest. By the sounds of it, he's got sufficient evidence based on history and the other children not having obtained any GCSEs to, you know, back up his case, really. And again, he can do that himself. He doesn't have to go and get advice on all of that. He may down the track, if things get a little bit complicated, want to take a one-off advice. But initially, he could just do that himself.
Brilliant. That's really helpful. I wasn't sure whether to push him down or direct him down to the local authority of either education or whether to go back straight back to court. So
I would go
that's
to
really
court.
helpful. I think the best. Yeah. Tie
Brilliant.
it all up into one application.
Yes.
Brilliant. Thank you so much. And your podcast and everything else so helpful. Thank you.
Oh, pleasure. Thank you, Steve. Thanks for asking the question. Bye-bye.
Hello.
Hello.
So my daughter's father, we've been to court previously twice before.
Yes.
The first time he was granted just video calls, which eventually brought down to abusive language and just problems on that end.
Yes.
He didn't see her for a few years, and then we ended up back in court where he applied. He was asked to do initial steps like go on a few courses and things like that
Yes.
before he could apply back to court. He did those, and then a few years later, we ended up back in court again, which was the beginning of last year.
Yes.
And he got granted steps to see her again.
Yes.
He eventually started seeing her again, but it's all sort of broken down now. She initially had some reservations about her security and how safe she felt with him, which I think have just grown. She's now sort of refusing not to see him, and it all sort of came to a head on Father's Day. He ended up assaulting my partner, her stepdad, my husband, and we just sort of don't really know where to go now, whether we go back to court, whether we put a non-molestation in place, as there has been one in place previously. We've been in touch with the police, but there wasn't sort of enough evidence to charge him.
Yeah.
So we're just sort of stuck in a rut of
Sure.
where to turn now.
The first thing I would say, Bubble, is that there seems to be a lot going on here, and I can hear in your voice that you're really worried about this. Obviously, that there's loads of questions I want to ask you, but I can't. So what I'm going to suggest is that you really consider getting that 1 hour of advice. Don't be put off by the fact that the police have said there isn't enough to charge him, because the non-molestation orders are dealt with by the family court, and the family court have a much lower bar than the criminal court, okay? So just because the police have given you that advice, take some advice from either, you know, somebody in my firm or whoever you want to go to about the non-molestation order, because I think that's important. If we've got, you know, situations where we've got assault, etc., then absolutely the non-mol is the way to go. So that's the second thing I would say. The third thing is, in terms of the fact the child now doesn't want to go, that needs to be investigated. We can't ignore that. And this is where I would really want an appointment with you, or a discussion with you, just to explore that. You know, why is it? What has she seen or he's seen? What has the child heard? How old is the child, obviously, and I'm not asking you to share it here, Bubble, but, you know, what is it? What's the background here? Because maybe we need to suggest to the court that we have to have some anger management courses thrown in. Maybe we have to have some separated parent courses thrown in here. You know, the emphasis is always on the adults. When children don't want to go and see a parent, there is usually an underlying reason. And children should never be put in that position where you have one parent saying, but I have an order, you have to come and see me, and the other parent saying, you don't have to go if you don't want to. And I'm not saying that's what you're doing, Bubble, but, you know, there is always an underlying reason. Because, look, we all know that children love their parents unconditionally. So, you know, there's usually a really good reason when a child says, I don't want to spend time with mummy, or I don't want to spend time with daddy. And this is where I would want to, as I say, speak with you, because I do think if the family court have visited it once and made a child arrangements order, that needs to be varied, or we need to be adding more layers to it. More layers, as I said previously, parenting courses, anger management, something like that for dad. Maybe slowing this down, you know, rather than having any overnight, and I'm not sure if he is, but really sort of slowing it down. Are we thinking supervised contact for a little while? Do you know what I mean? So for your
Yeah.
case, Bobble, there's a lot going on there. I would say get some advice.
Yeah.
All
Okay,
right.
brilliant. Thank you so
No
much.
problem. Good luck with that. Bye-bye.
So we're separate with the child's mother,
Yes?
and she took him for a holiday without my consent. And I
Okay.
wonder, what can I do next?
Has she brought him back?
Not yet, and I'm not sure if she willing be coming back because there is a pre-trial hearing coming up on Friday, and she might be facing repercussions for false allegations and false statements to the court.
Okay, so are you in family proceedings at the moment? Child arrangements proceedings at the moment?
Not yet.
Okay.
First we have to finish non-molestation order, which I'm disputing,
Okay. And what country
and
has she
then
taken the child to?
I've been told that she's taking him to Turkey, but I can't confirm that. I've rung everywhere I can,
Okay.
border force, police, anywhere. Nobody can help me. Apart from they admitted that yes, it's wrongdoing from her,
Yeah.
not asking my consent,
Yeah.
and there will be interview in a few days.
Okay.
But they say they can do interview only when she will be back.
Yeah. When were you expecting her back, or aren't you? Like, did you not know a date?
I didn't know. I didn't know at all. It fall into my days when I had to have him Monday, Tuesday, Wednesday.
Yes.
But I have to mention that there is no court arrangement for that.
Okay.
So it's based on a verbal agreement
Just
in
an
between
informal
us
agreement.
on the
Yeah.
parenting app
Yeah. Fair enough.
because the
Okay.
court.
Well, you've
Yeah.
got a bit of a tricky situation because you're not in court proceedings at the moment, which means that technically UK or the English courts don't have jurisdiction. Nothing's before the English courts. And of course, we will always start court action based on where the child is living. So my suggestion is going to be wait until she has formally missed a date that she is meant to be back for. You mentioned something about a pre-trial for the non-molestation. If she misses that, then you are probably satisfied that she's not going to come back from Turkey, or that there's something untoward going on. And then you really need to take legal advice. Now, this isn't going to be a straightforward application, because we're going to have to look at Turkey's jurisdiction. It's going to involve things like, I don't want to get too technical, but the Hague Convention is going to have to be considered because we are starting potentially a children's application when the child has already been removed from the UK. Okay, so it's definitely something that you need to take advice on. By all means, you can come back to my firm if you need to. But I'm going to suggest in the first instance, you wait until she's definitely missed the date. Because if she's got a pre-trial hearing on Friday, she may well come back. Going back to your original question about she went on holiday and didn't ask my permission, what can I do? Well, when she comes back, you would want to get a child arrangements order in place that's very clear about when she takes the child on holiday and for how long for. You know, there'll be no consequence to her if she comes back. The family court won't have any consequence for the fact that she didn't ask your permission. A slap on the wrists will be the most that they will suggest. You know what I mean? But I think the bigger issue here is she going to come back? That would be where I'd be most concerned.
You had Jean-Claude Van Damme on earlier.
Yes?
It's said legal query. My apologies. I forgot to ask about child holidays. What if I, as a father, will take the child on holiday without telling the child's mother? Am I going to get the same slap as she will?
Well, absolutely. You know, the court don't differ in their penalties, whether it be a mother or a father. I'm not going to recommend that you do that, though. Clearly, there is contention between these parents and the co-parenting relationship has broken down. Okay, so the fact that mom has gone on holiday without seeking dad's permission and dad has now lost out on contact isn't great. You know, it's not appropriate. So my advice to that father would be, let's not enter into a tit for tat. Let's go to court and get a C-100 form. Because, you know, who's to say that he then takes the child on holiday without mum's permission and then mum starts to retaliate? The only person that's missing out here really is the child. So I think sometimes it just takes one of the parents to be a little bit more mature and just say, okay, that's not great, but let's get into court and get a child arrangements order. That's what I would be suggesting.
I've not seen my children for 9 months. I was removed from the family home July last year. I saw them on Father's Day. We started mediation, and my priority is obviously having child arrangements for both my daughters, and her priority is the house. She's severed the joint tenancy, and she's proposed a buyout, which is 50% less of my share. And I feel like obviously the property and the financial matters is being kind of used to see if she will arrange or give any sort of access. I've got non-molestation order which I'm contesting, so I haven't started the C-100 yet.
Yeah.
But what are my options regarding the house? Because potentially, could I say, you know, we'll put a masher order in place until the youngest is the 18, and would that affect my 50% equity, or would that? What are my potential options regarding the house? I kind of know what I need to do with the children.
Let's just take it back a step. Did you say that you were married or not married?
Not married.
Not married. So therefore, the measure order's not going to apply, first of all. Okay. So when we're not married, we are looking at property ownership in a very black and white way, in that if you hold the property as tenants in common, or joint tenants, and now it's tenants in common, it doesn't really matter. But if you hold equal shares, that's what you're entitled to, okay? Regardless...
She's severed the joint tenancy a few weeks ago as well.
But that's okay. So all that means is, as joint tenants, you would have held 50-50 each, okay? And if you had died, your 50% would have automatically gone to her. By severing the joint tenancy and holding it as tenants in common, you're still holding 50-50, but now what would happen is if you died, your 50% wouldn't automatically go to her. It would go to whoever your beneficiary is in your will. So it's really common when a couple split up, that one of the first things we do is we sever the joint tenancy and we hold it as tenants in common, okay? Because we don't want our ex getting half of our property if we do pass away. So, but that's fine. That won't have altered the fact that it's 50-50. All right. So it's still 50-50. Now, you're not...
Even though I've stopped paying the mortgage because I can't afford my rent.
But it's still 50-50 because nothing has changed at Land Registry. Regardless of who's paying the mortgage, the legal ownership is still 50-50. So what that means is, because you're not married, she has no automatic rights to that property above the 50%. So your option is you can either have her buy you out, or that if she can't afford to do that, the property is sold. Now, the remedy available to her, because she's not your wife, she can't then go to court and ask for any other financial help for her. But what she can do is go to court and say, I can't afford to house his child based on my 50%. So I'm going to be asking for a little bit more because I've got the responsibility of housing his child. And we call that a Schedule 1. But it's a financial application on behalf of the child and not her. If that happens, you need to get some advice. But your question to me wasn't about that anyway. It was about, what are you entitled to? You are entitled to your 50%. Legally, you are. That 50%, and her options are buy you out or sell the property. But the measure order won't apply to you. That's only for married couples.
I see. Okay.
Does that make sense?
It does. Thank you very much.
That's
and just a quick follow-up question, because I'm really trying hard through mediation to kind of not go through the family court, because 10 years ago I was in the predicament and I kind of understand how the family court system works and the delays, etc., the costs involved. So I'm really trying hard through mediation to get some sort of reasonable contact.
Yes.
But I just feel like she wants the house less than, buy me out
Yeah,
dirt cheap. And my theory is
yeah,
once I've sold the house to her, like for undervalued,
yeah,
she would remove any contact afterwards.
yeah. So
And
what?
how can I protect myself in that
So
situation
what?
without going through the family court?
Well, you can't. I'm not. I'm not going to, dress it up. You can't. But don't think that it's going to cost you a fortune, because if you want to have a relationship with your child, and for whatever reason she's saying no, or maybe you guys can't agree on what that contact looks like, you simply fill out the C100 form. You don't need a solicitor to do that for you. You just do it yourself, okay? So fill out the C100 form and send it into
Yeah, I've got it
court.
all drafted. I've just been
Brilliant,
holding tight just to see if I
brilliant.
can get mediation sorted. But
Yeah,
just say if I did have to go through
yeah,
courts through Talata,
yeah.
I believe it's quite expensive.
Well,
Is it recommendable to kind of do Talata yourself? Is it possible?
okay, so hang on, you're bouncing about, because Talata now you've gone back to the financial predicament, okay? But let me just clarify, that C100 will get you the child arrangements order. So, and
That's
one
correct. Yeah.
one isn't conditional upon the other. So you can continue down the C100 route without it impacting on the Talata. Now, the Talata application is if she isn't willing to buy you out and she won't agree to the property going on the market for sale. Is it expensive? No, absolutely not. You are asking the court for an order for sale in that instance, and you can represent yourself. Okay, so again, don't be, and I say this because there's other people listening who might be thinking the same thing. You can represent yourself if you want to. All I would say for a Talata application is make sure you get at least that 1 hour of advice, so that we can let you know what your prospects of success are. We can go through the forms with you. You're going to have to do a bit of a statement for Talata. It's not a straightforward application, but not hard at all. Not hard at all. But yeah, just get that 1 hour advice, and then you can, represent yourself if you wanted to.
And could I make an argument where I left a year ago that I could potentially claim occupational rent?
Yes, you could.
If she argues that she wants that.
Just for completeness and for the fact that the people are listening, absolutely you can make a claim for occupational rent. But you mentioned to me earlier that you hadn't been paying the mortgage. So the flip side is that she will then argue that she's been paying your half of the mortgage for you, and then the court might decide that one cancels out the other. But yes is the answer to your question. You can apply for occupational rent.
Where I've got non-molestation, which I'm going to contest, does that have an effect when you make an application for contact for the courts?
Depends what the outcome is. So if the non-molestation is just confined to her, in other words, you don't go near her, you don't contact her directly or indirectly, then no, because it's not including the children. So your application on the C100 is going to be all about the children. So the answer would be no, it won't impact. It might impact handovers. Sometimes we have a non-molestation, so mum can't do the handover, but that doesn't mean that somebody else can't do it. But if the non-molestation, and they don't usually, but some of them will, include the children, then yes, of course it will. So it will all depend upon the non-molestation that she's applied for. Is it just for her, or is it for her and the children?
Her and the children, but obviously I've still had like supervised contact with the children.
So then it is going to come down to the wording. But in your defence of the non-mol, you want to be pointing that out to the court. You want to be saying to the court when you defend your non-molestation order, the court needs to recognise that I also have a C100 in. So we don't want the non-molestation order to jeopardise the children having a relationship with me. And it's really important that the court know what your intentions are so that they can leave a little bit of wiggle room in the non-mol and how they word that to enable some form of contact to go ahead.
Thank you very much.
Pleasure.
My ex-wife is now, it's a weird one because I feel like I'm getting a bit trapped that she's now, because I'm not signing the house over to herself.
Yes.
Obviously it's a joint mortgage.
Yes.
I'm the only one that paid the mortgage. I pay my half still, even though I do not live in the house. She's now saying if I don't sign the house over, that she's going for spousal maintenance.
Right.
But I am aware that she gets obviously benefits a lot. I pay the CSA, half a mortgage. She has a small business, and cash in hand work, what are my chances of getting slapped with a spousal maintenance, even though there's proof and evidence of all these things?
It's difficult for me to answer that because spousal maintenance is based mainly on her need. Okay. So she has, or what she's about to say is that she has a need. Her income, whatever she's got coming in, including any child maintenance that you might be paying her if you are, or mortgage payments or whatever, isn't enough for her to survive. And she's then saying, I have a deficit that he needs to make up. But of course, the flip side to that is, well, hang on a minute, is she maximising her earning capacity? That's always my first question. Is she doing enough? We call it mitigating their circumstances. Is she doing enough to bring in her maximum income? So, and that's difficult. That's why I can't answer your question, because I don't know the figures and the facts, and please don't tell me on this public forum. But do you see what I mean?
No.
She can certainly make the application, but it's whether or not it's going to succeed. I would kind of need an appointment with you to discuss that.
Yeah, it's just because she keeps threatening it because I won't sign the house over fully. Obviously, I have left. The divorce is going through as done. I've just done a deemed service as far as I'm aware, because she received it but declined to sign it. So luckily, I've done a sole divorce.
Yeah.
But because she's not getting what she wanted now, she's now saying that she's going for spousal maintenance. But what I've seen is it goes through mediation first as well, as far as I'm aware.
Yeah, because before you make any court application, the judges now are looking for the parties to at least attempt mediation. You know, mediation's not compulsory, but they are hopeful that the parties will at least attempt to settle at mediation. So, yeah, she will have to do that bit first. And look, it's not a bad thing. It's not a bad thing to do mediation.
No. I mean, on that mediation front, when I was speaking to a solicitor previously about the divorce, he said because there's domestic violence and financial violence that has gone on within the relationship, if you think she won't, which I'm 90% sure she won't, you can apply for, is it the Maya certificate, to say that there was obviously stuff involved, but it's not going to go ahead, sort of thing.
So typically,
is that right?
Absolutely, yeah. So it's the MIAM certificate, which is the form that the mediator signs to say that the parties have tried mediation, it was unsuccessful. That's the form that we need to attach to our court application. But what happens in practice is that the mediator will be given the referral, and she will ring, or he will ring both of you. And if one of you say, I really don't want to go to mediation, I don't want to be in the same room as them, or I don't even want to try it. As I say, it's not compulsory mediation. Then the mediator will sign the MIAMS form to say mediation wasn't appropriate, and then it will be sent to whoever's asked for the MIAMS form. So yes, it's and it's the court's way of saying, well, at least the parties considered it, at least they gave it some thought, but we can't force people to go to mediation.
So I'm currently representing myself.
Yes.
I left the relationship at the back end of last year.
Yes.
In April this year, since she found out about my new relationship, she stopped all contact.
Okay.
She's now claiming safeguarding concerns that don't exist. I've submitted my C100, my C1A. I've received the documentation back from the court now.
Yes.
Do I have to serve them to her, or will the court serve them to her?
The court generally serve, but I always, just as good practice, will serve my opponent anyway, just because I want to make doubly sure that they have received the application. So it wouldn't hurt if you have her email address to simply email her, as long as you're able to do that, and say, please find attached issued court application by way of service upon you, something like that. Just short and to the point.
Perfect. And then just another quick one on top of that as well. I've seen your TikTok videos about significant financial contribution.
Yes.
So I invested about £15,000 into her property.
Yes.
I've got invoices, receipts for the whole thing. Is there any chance of getting that back, or is it not worth pursuing?
So when I talk about that in the videos, I'm directly addressing non-married couples. So let me just check that first. You're not married.
That's correct, yeah.
Correct, okay. And obviously the house is in her sole name.
Yes, I moved into her property.
Yeah. So if you have made a significant contribution, which by the sounds of it you have, then absolutely. Usually we're going to court for one of two reasons. We are saying that the contribution was so significant, we actually think that we should own part of the house. Or we are saying that the contribution was such that it was a lot of money. It wasn't a couple £100, in your case, £15,000, and I would like it back. And then, of course, the court's going to want evidence of that by way of receipts or transfers from your bank account. But yes, absolutely. I mean, try mediation if she's agreeable to that. If she's not, then yes, it will be an application to the court to get that money back.
Yeah, I attempted mediation for the custody and contact, and she just
Yes.
refused to engage. Didn't want to attend
Okay.
it, so I've got the signed mediation and got the C100 back.
Got you. Okay. Well,
The
yeah.
financial contribution, how would I start that?
So it depends what you're going to pursue. Are you going to pursue a share of the property, or are you going to pursue that you want the money back? If you want the money,
I just want the money back.
Okay, so then you want to be looking at a small claims. Okay, so if you just go onto a Google search or into the government website and type in small claims, it will take you to notes. And the notes will tell you exactly what you need to do, the forms that you need to fill out, the cost of making your application, and what happens from there. Small claims is really straightforward. My suggestion is always just start with the government website. The reason I say that, I actually had a question last night from somebody on Instagram, and they said to me, oh, there's all these other firms out there that are promising to do the same for a fee. And I never know if it's a scam or if it's a genuine. So I always sort of direct people, just go to the government website. Everything is on there. It's the English courts that are dealing with it, and they're all, operated by the government, obviously. So that's always your best bet.
Perfect. Thank you very much.
Absolute pleasure. Thanks so much.
I've got a divorce paper signed and done, and I have to pay my ex a settlement figure. Now that figure's I need to do that by November. So currently going through mediation again to sort out the childcare.
Yes.
She is arguing that I can only spend time with my child once a week in the week, and then every other weekend. So yeah, one night in the week and then every other weekend. I'm actually arguing for only 2 nights in the week and every other weekend.
Yes.
So my question is, if we can't get an agreement, Clare is going to have to go to court.
Yes.
What is it better for me to take her to court or for her to take me to court?
I think because you're the one that wants the contact, she has no motivation to go to court. I assume the child lives with her, first of all. Is that right?
Well, currently we're still in the same house.
Oh, I see.
Until I pay the settlement figure,
Yeah.
she's not going to leave.
Oh, I see.
So,
Okay. Well,
that's where we're at now.
Okay, so let's say that you've given her the settlement figure and she leaves. Is the assumption that
Yes.
your child is going to go with her? Is that sort of, you may not no. Okay, that's fine. So,
And I'll just quickly tell you the reason why that's not the assumption is because because we've already agreed that who takes our child to school.
yes,
That's already been agreed, so she can't really change that. So
I
he
see.
will still have to come to me on those days. So
Got
yeah,
you.
she won't stay with him.
Okay,
Yeah.
got you. Well, then I would suggest that you are the applicant. You seem more motivated to get a structure in place. You're very clear as to what it is that you're asking for, 2 nights every week and alternate weekends. So I would suggest that you make the C100 application, plus you then remain in the driving seat. The courts don't judge whoever makes the application, that they're not going to judge, but I always think it's better to be the applicant, because you are in control then of when the application goes in, exactly what you're asking the court for, and of course the onus is on her to say why she doesn't agree with that. The differences are minute. It's almost going to be harder for her to say, I don't think he should have 1 extra night per week, than it is for you to say, I'm only asking for 1 night per week, an extra 1 night per week. Do you know what I mean? It's going to be very hard for her to defend that. And that's the position from a strategic point of view that you kind of want to put her in. So I would say you make the application.
Cool. There you go. That's what I need to know. Thank you very much.
No problem at all. Thanks.
Hiya.
Hello.
So my partner, his ex put in a C100 form last year,
Yes.
or the year before. They had a court hearing March 24, and they've had no court order since. As a result, he's had to start seeing his son in a contact centre because there's no contact between him and his ex. I'm just wondering what we can do, because I put 2 formal complaints in, had a solicitor contact the court, and there's still nothing.
So when you say no order was made, you're talking.
There's been absolutely nothing from the court at all.
Okay.
Nothing after the hearing. There has been nothing.
But what actually happened in the hearing?
So basically, what happened? She put in a false allegation for rape, and there was bail conditions in place, so my partner couldn't have any contact with her.
Yes.
So it went straight to court.
Yes.
In the court, in the C100 form, she'd put a load of false allegations in there about emotional neglect.
Yes.
And some parenting issues she had with his parents.
Yeah.
So
but what
they said that they were going to do a fact-finding hearing.
Okay.
But there's been nothing.
Okay. So it could be that we're waiting for a hearing date then. And how long ago was that hearing? When was that hearing?
March 24.
Okay.
So over a year and a half ago.
Yeah. So it could be that the applications got lost. I hate to admit that, but sometimes that happens. You know.
We have contacted them, and I put in 2 formal complaints in December and in May.
Yeah.
I've contacted the local MP. They contacted the court because it was one that wasn't local to us at all, wasn't local to Mum.
Yeah.
We believe that it was moved because she works in the police.
Yeah.
But we didn't actually get an answer to that.
Yeah.
But they replied to the local MP.
So I would be, if I was in your shoes, and great, you've made the complaints and you've gone to the MP and all the rest of it. Not really getting you what you want though. I would be inclined to just make another application. I would just start again. You know,
Okay,
and
so that is possible.
yeah, absolutely. Just make another application. And when it comes before the court and you're actually in the courtroom, I would be addressing and saying to the court, look, because they'll be able to, with the child's name and date of birth, put it into the computer and see that there has been a hearing. And they can kind of pick up where they left off. It's not great, don't get me wrong, Jessica, you know, it shouldn't happen like this, but it has. And I think sometimes we kind of have to just deal with where we are. So, you know, fair play for making the complaint. But I think in order to have him have a relationship with the children, just start again, put in another application. Yeah, C100.
And with that, how does the mediation work? Because obviously before there were bail conditions, so they couldn't have the mediation.
Again,
so do we still need to apply for mediation?
Absolutely, yeah, because when he does the C100, it's going to ask for a MyAM certificate. So he's going to have to reach out to a mediator. If his bail conditions still apply, he's going to tell the
they don't.
Okay, well then it may be that they have to go to mediation. He'll speak to the mediator about that. If he doesn't want to do it or she doesn't want to do it, as I said to a previous caller, we can't force people to do mediation. But yes, he will need a MyAM certificate, definitely.
My wife and I can't come to an agreement on a financial settlement.
Yes.
She has agreed to amount of the equity of the house, but she will not agree to split pensions.
Yes.
Hers is an NHS pension.
Yes.
So hers is more than mine.
Yeah.
She is refusing mediation too. However, I am going ahead with my appointment.
Yes. So what happens there, where we can't agree on a financial settlement and the other party won't go to mediation, go ahead with your mediation appointment. The mediator will then give you the MyAMS form because the other side will simply refuse to engage in mediation. And as I've said a few times this morning, it's not compulsory. It's definitely voluntary. So they will give you the MyAMS form, and this person will then use that to apply to the court for a financial order. And then the judge will order this person to provide their documents and will most likely order a pension share. You know, pension shares are made, but limited to all contributions made during the marriage. Okay, that's really, really important. So if you're getting divorced and your marriage has been 10 years, we're looking at the contributions made in those 10 years, not all of the contributions, okay?
My ex-partner's taking me to court tomorrow for child arrangements order, and I haven't had time to get a solicitor. However, professionals said that it deemed safe to have contact. Do you have any idea how it will go for me tomorrow, please?
If it's the first hearing, the court's going to want to hear both sides' position. So the person that's made the application, the court will say, okay, what is it that you're looking for? Alternate weekends or shared care or whatever that might be. And then the other person who's asking this question will be asked by the court, what are your objections to that? And that's their opportunity to say, well, I've got welfare concerns or safety concerns, or the other parents got addiction issues or whatever it might be, anger issues. And from there, the court will then make directions. They won't necessarily make an order on the first hearing for contact. Generally, they will get CAFCAS involved because CAFCAS are seen to be an independent third party. So that's typically all that will happen at the first hearing.
The next one I have for you is there's a child arrangement order in place already. I've asked the father to change the times to suit the son's needs and asked dad to pick up from son's home address. Dad refused. Do either of those things, not turning up for these visits. This was 7 months ago. Should I do anything? And the reason why she's asking for a change of times is because dad was failing to feed the child.
Okay. Look, I think that here is a parent that's really trying to co-parent by the sounds of it, and the other parent is making it extremely difficult, would be my guess. So, you know, if he's refusing to feed the child and she wishes to change times, I think that's perfectly reasonable to ask. Personally, I would be insisting that father fed the child and took responsibility for that. But the second thing I would add is that if dad's simply not bothering and not turning up when he should, worry less about that. You know, that's, you know, as long as she's not allowing dad to just walk in and out when it suits him, then, you know, focus on her relationship with the child. And I say that cautiously because clearly this mother wants the child to have a relationship with father, and she's trying to appease father and do what's in the best interest of the child. But she has no incentive really to go back to court. She needs to exercise her parental responsibility and simply say, this is what's in the best interest of my child. If you're not going to feed him, then he's coming back early, or whatever that might be.
Yeah, brilliant. And the last one I got for you, I've just plucked from the TikTok, and I think it's quite a good one, really.
Okay.
So I'm assuming it's going to be a child arrangements thing.
Yeah.
But how does divorce work when one parent resides in Scotland and the other lives in England?
Well, it works exactly the same way in that depending on where you start the divorce. So if the person in England wishes to start the divorce, then fine, they can do that regardless of where the other person's living. A lot of times I will do a divorce where I've got my client in England, but maybe the spouse is in Australia or America or Dubai or wherever. So it doesn't really matter. But if the question I'm being asked is, I want to start the divorce in Scotland, absolutely fine as well. I wouldn't be able to comment on that though, because obviously I don't know Scottish law. The only thing that I would add to that is wherever you start your divorce, and a lot of people start their divorces overseas for a variety of reasons, be sure to know that usually whoever starts the divorce, in other words, the country of jurisdiction, they will normally have jurisdiction to sort the finances out. And sometimes the country where you start your divorce isn't, let's say, favourable to women, or isn't favourable to the person that hasn't made a financial contribution. So you want to be mindful of that. Don't think that if you start your divorce in Scotland that you can then come to the English courts to sort out finances. The Scottish courts might then say, absolutely not. We have jurisdiction here and we're going to do that, first.
Yeah. Bill, that's all I got for you at the minute.
Great question, though. Thank you, Mart.
So basically, first of all, I wanted to know if people on universal credits get any sort of help with taking their ex-partner to court, if it's like some, payments or anything like that.
So I think what you might be referring to, Gosia, is legal aid. So you can still get legal aid for family, but only for specific cases. The first thing I would say is that you have to show that domestic violence has been involved. You'd also want to make sure that you satisfy the merits test. The merits is, do you have a good enough case for the government to pay for this? How you find out the answer to those questions is by giving the Civil Legal Advice line a call, okay? And their number, Mart, I see you're still here. Do you mind pinning this for me on the TikTok? Their number is 0345 345 4345. So if you give them a call, Gosia, they will go through both your means, which is the money that you've got available or not available, and the merits of your case, and they will tell you if you qualify for legal aid. All right?
That's perfect. So basically, I have a 4-month-old daughter. I recently just broke up with my ex-partner for it was just like a toxic relationship. He was not very good to me or my child. And when I was pregnant, obviously I had to call a police for domestic abuse, and I was wondering if Clare's laws would be like a proof of a domestic violence in court.
Yes, potentially. You can do a Clare's Law request. I think that specifically, are you saying that he is asking for contact? Is he actually asking?
Yes, he is, but I don't think he has like any intention of looking after the baby, if that makes sense. He's just doing some things to like sort of spite me.
So there are two options then. He will either, you'll say no to contact, I'm assuming, because you've got safeguarding concerns, which means that he can, if he wants to, make an application to the court. And then if he makes an application to the court, you will attend court and you will tell the court what your concerns are. That's option number one. Option number two, you might think, well, actually, I don't think he's going to make a court application and he may just take the child. So then you might want to use the C100 form to apply for what we call a prohibited steps order. And that will give you an order that prevents him from taking the child from you. It doesn't mean that he gets contact. It's just an order that says he will not remove the child from your care.
And I was wondering, because I deal with depression. I'm currently on antidepressants, and he keeps threatening that for that reason I am gonna get my child taken away.
Yes.
Is that some sort of like a issue in court that I am on antidepressants or anything like that?
No, not really. I mean, so long as there are no safeguarding concerns with baby, no, that won't be considered. If he raises it, CAFCAS might be asked to intervene. But no, I mean, based on what you've told me, and obviously I don't know any more than what you've just told me about your medical history, but I would say no. I mean, if there was a real concern, social services might well be involved by now. But
that's fine.
Yeah, I think you'll be all right there, Gosia. Okay.
That's fine. And also, what was I gonna say? He is saying that he will fight for like a 50-50 custody.
Yeah.
Because I don't agree that he should have our baby for the whole entire week. Only because the way I see it is he drinks a lot, he goes out a lot, and he wouldn't be the one to look after the baby. He would leave her with someone else. Would I be able to use that sort of as a case in court that he wouldn't be the one looking after her if
So
he does get like a
I think the first
custody?
thing, what you need to do first of all is wait until he makes the application. I mean, a moment ago you said he probably wouldn't make the application and wouldn't go to court. He might just be threatening it. If he makes the application, then fine, you would meet it then. But the second thing I would say is that the court generally go on the status quo. So if the child has been living with you, it makes it difficult for him to then get any kind of shared care order, okay? If the court were considering it, then again, yes, as the same answer as I gave to your first question, you would raise your concerns with the court and say that he drinks a lot and chances are he wouldn't be the one looking after the child. Okay?
That's fine. That's perfect.
Brilliant.
That's all I wanted to know.
Thanks, Gosia. Thank you so much. Bye-bye.